Kia ora koutou. Welcome everybody to today's webinar. I'm Elaine Kohler from Prince, and I'd like to welcome Tania, Goatley and Kristin Wilson from Gully, who are our presenters in our webinar, Under the Influence, Content Creation in a Changing World. Before I pass it over to Tania and Kristin, we do have a poll that will pop up halfway through the webinar. It'd be great if you could please answer the poll using the little buttons that pop up, and there'll also be several opportunities for questions. We'll stop in the middle for a couple of questions, and then we'll also have time at the end for questions. The webinar is being recorded, and please also take the time to answer I think 30-second poll really at the end of the webinar as you close out. Thank you. Welcome Tania and Kristin, and over to you.
Thank you. Right, hello everybody. Thank you very much for tuning in today to this webinar. So today's topic is Under the Influence, Content Creation in a Changing World. So what we're going to be looking at today is, we've really got 4 topics that we're going to be covering. The first is what you need to know about influencer advertising and working with influencers. This is a very hot topic at the moment, and something that the ASA in particular is really taking an interest in, so it's quite timely and important. Media partnerships and how to deal with relationships with media entities, including native advertising and the watch outs there. Then we'll hand over to Tania, who will discuss social media comments and the ways in which brands can run into difficulties from having people comment on their social media pages, followed by an update on defamation and how aspects such as defamation and freedom of speech are balanced out. So we'll start off looking at influencer advertising. There's really 2 key takeaways from the session today that are important to keep in mind. The first is making sure that everything is sufficiently clear when influencer advertising is occurring, and identifying properly that content is advertisements or there is some sort of commercial incentive or relationship there. And secondly, making sure that any influencer content that's being put out is truthful and not misleading, because there can be backlash to both influencers and brands if you're not cautious in that respect. When we're talking about influencer advertising, for the purposes of the ASA code, ASA considers influencer to be a broad term used to describe people who have influence over choice, opinion or behaviour of their followers. An influencer is someone who has access to an audience regardless of size, so even someone with only a comparatively few number of followers can be considered an influencer for the purposes of the Advertising Standards Authority. And it's someone who has responsibility for their own organic content and content that may be commercial or that they may derive some benefit from. And influencers are able to provide a platform for media advertising, so they are increasingly being recognised around the world as an area in which regulators are taking an interest to make sure that consumers are adequately protected and that people aren't being misled through posts which involve a relationship between brands and influencers. It's an interesting area of advertising because there will be some consumers of this content who are very savvy and know perfectly well that if an influencer is recommending a brand, then there's probably some sort of commercial relationship in the background. However, influencers, one of the benefits of using them is that things can come across as very organic and genuine, and people respect the opinions often of these influencers. So it is a relationship of trust, which has the potential for being abused. So across the world, we've seen regulators taking much more interest in how influencer advertising is being managed. And that's really jumped up and stepped up in New Zealand. Probably only over the past few months, ASA has gone in all guns blazing to try and make sure that it's clear what the expectations are. So the starting point, as you'll all be familiar with, is that advertisements must be truthful, balanced, and not misleading. So with influencer advertising, the key things to make sure of is that if the content is an advertisement, then it's properly identified as an advertisement, and then under that, whether ensuring that the content itself is not misleading. So working out whether it's an advertisement is not always going to be entirely clear. The ASA's definition of advertisement is a lot wider than what most people would expect an advertisement to be. They define advertisement as any message, the content of which is controlled directly or indirectly by an advertiser, expressed in any language and communicated in any medium with the intent to influence the choice, opinion, or behaviour to those whom it is addressed. So it doesn't apply to things like news, to genuine reviews, to product packaging, for example, but really has quite a wide ambit as to what could be an advertisement. And I think that the ASA in particular will be taking a fairly broad view over what could be captured here. The issue of control will come to soon as to where the red flags are, where a brand has control over a influencer's actions. Payment is an interesting one because what the ASA will really be looking for is whether there's any kind of incentive there or commercial driver for posting particular content. So that can include things like an influencer being provided with a free gift or any kind of bonus or anything that would be likely to make the influencer think more kindly of a brand may be sufficient to be payment for the purposes of turning this over and making it so that the post is considered to be an advertisement. So some examples here of what advertiser control could look like. Obviously at the one end of the spectrum you've got editorial control, where you might have a brand partnership where the advertiser or the brand can see a post, suggest wording, control a post or give it a sign off. Obviously in that case the advertiser has control, but it can include also content that's provided by the advertisement, provided by the advertiser, inclusion of a link to the advertiser's website, a prize draw or a giveaway, content about a free gift can be sufficient to constitute control, and including a discount code or affiliate link can also indicate that there is that commercial relationship and incentive there, such that the relationship needs to be properly disclosed. If it's an advertisement, there needs to be it needs to either be made clear through the context that that is what is occurring, or there needs to be identifiers in place to explicitly state this is an ad. So it will be a matter of the overall impression that's given. If, for example, an influencer is in a TV commercial for a brand, it's going to be fairly obvious that this is an advertisement and it is paid. If, however, you're scrolling through your Instagram feed and happen to see someone wearing a particular item or saying they've been to a particular place, it may be a lot less obvious, in which case the sort of disclaimers and identifiers are much more important. So when considering how far to go and what needs to be done in order to identify an advertisement, you need to consider the nature of the content, where it's placed, how people will come across it, for example, as well as how obvious the brand tie-in or relationship may be. So one way of making sure, if there's any doubt about whether it's clear enough that a post or something that's been produced by an influencer is an advertisement, is to put an identifier on it. So what the ASA recommends is to unambiguously state that this is a hashtag ad, hashtag advert, hashtag advertisement, and then you can include other hashtags to sort of narrow that down as to free gift or partnership or branded or anything like that to make it more clear again. You'll see there that on the slide we had, when we put together these slides last week, hashtag sponsored was one of the terms that had been recommended in various decisions. The recent guidelines that have been issued from the ASA have said that hashtag sponsored may not in itself be enough to signify an ad, which is quite interesting, we thought, given the previous guidance that's been issued. This is because some social media will have sponsored content or indeed promoted content that is not necessarily an ad, but it's just been allowed the post to greater prominence. So there's a risk that even if you say hashtag sponsored, that's not going to be enough to signify the commercial relationship that's in place. Common mistakes that can be made. So it really needs to be clear to consumers without any doubt or hiding that this is an advertisement and that is sponsored content. If you've got, for example, a dozen hashtags and one of them in the middle there is hashtag ad, that could be problematic, as in it could not, may not adequately disclose what the relationship is and what is being, what the nature of the content is. There's an issue if an identifier is only identified through another link, or you have to click into another page in order to find out that it's sponsored content. For video content, it needs to be made clear up front what the relationship is. It's frowned upon if you have, for example, a 3-minute video and at the very end it says advertisement brought to you by X brand, because by that stage consumers may have already been misled or being led to think a particular thing that is not correct and may have been influenced in that way. Also with video, the ASA recommends that you specify that it is an advertisement in writing as well as just orally, because a lot of people scrolling through their social media may not have sound turned on and so may not notice that there's been a voiceover stating that it's advertised content. So it's really making sure that you're upfront and that no one's in any doubt about what the nature of the content is and the relationship, and that there is a relationship of sorts between the brand and the influencer. Right, so we've got our poll now actually, which is a little bit earlier than halfway through, but Rena, if you could maybe run that for us. So the question we've got there is, have you ever given a product to an influencer without discussing how that product is going to be used? So I'll just give you a minute to fill that out before I expand on why we're asking and the new guidelines that are in place.
I'll close that off now.
Thanks. No, cool. Well, that is safer to not give product, but of course a lot of brands will give product to influencers, or might sort of send out something new to a bunch of different people, hoping that someone picks it up and does something with it. The recent ASA guidelines, one of the things that was particularly interesting is that they take quite a hard line on free gifts, as in if a brand provides something to an influencer, then they will be, and if the influencer posts content about that, that will usually be an advertisement that needs to be disclosed, and the brand can be responsible if the influencer does not do that properly. So even if a brand does not have a sort of long-standing relationship in place, even if they don't specify how content is to be used, even if they just say, hey, look, we thought you'd like to try this, here you go, that can cause a problem if the influencer then posts about the product. And the reason for that is essentially, I think, to try and make sure as much as possible that where there's any kind of commercial incentive there, that is disclosed. Because when a brand is providing a free product to an influencer, they're doing it really for purpose in almost every instance of getting more publicity for the brand and advertising that product. So it is a hardline approach. So for brands that are engaging with influencers, you do need to be careful about who you are engaging with and making sure that they understand what their obligations are. And the ASA goes so far as to suggest that you should specifically state that if you post about something free we've given you, you need to identify that as gifted content or as an advertisement. So the standard is quite strict there. So I guess it's just exercising additional care when you're giving product. So we'll look at a couple of recent decisions and actions by the ASA. You'll probably be familiar with the case that was recently, the complaint that was recently brought against Simone Anderson. So this was important because this is the first one that's been upheld as a complaint by the ASA. So there were two different posts that were at issue here. The first one, there was a photograph of her wearing activewear, saying, "A little stroll this morning was so gusty, crop and tights at Oceania," and then Simone 10 in quotation marks. So for some people seeing content like this, it would be instantly recognisable that there was some sort of relationship there or some sort of commercial relationship, but for others there wouldn't be. So the Simone 10 in quotation marks is an affiliate code. So what happens is you can go to the Oceania website, enter that code, and you get a 10% discount. And I can't remember the exact finances, but Simone Anderson also got money for that. So one of the things that the ASA took into account particularly was that if there's a financial incentive going directly back to the advertiser, going back to the influencer rather, that's the area where particular caution is needed, and you need to make it really clear that this is a post where content has been provided, there is a commercial relationship there. So looking at this particular post, she had received free activewear from the brand. There was that affiliate code, and there was clearly an intention there to, and from her part, to influence people to purchase. It wasn't sufficiently identified as an advertisement. Now, when the complaint was first made about both of the posts that we'll discuss, they added the hashtag, hashtag gifted, to signify that there had been a free gift. The ASA held that this wasn't enough to give an explanation of the full extent of the commercial relationship, in part, I think, because hashtag gifted could be ambiguous, akin to hashtag police, or another hashtag that's not immediately obvious compared to hashtag advertisement, which would make it crystal clear that there is a commercial relationship there or some sort of financial incentive. So that complaint was found to be upheld as in not being sufficiently clear that it was advertising. The other post that was referred to in the complaint related to Quarters Hotel. She'd been provided with a night's accommodation and then posted about having high tea, and it was such a treat. And you could go to the Instagram to win a prize. And then she also tagged where her other clothes had come from. Again, that was held to be not sufficiently disclosed that this was an advertisement. She had received something for the post. The intent was to influence people to stay at the hotel or to go to high tea at the hotel or to direct people to the brand's page. Again, the commercial intent wasn't sufficiently made clear, and hashtag gifted was not enough. So we'll just look at a couple more decisions before I hand over to Tania. The first one that I referred to there related to the hashtag SP. So this was a post that was posted by Aunt Green. He was holding a bottle of Heineken and I believe challenging one of his friends to have a Heineken or offering Heineken to one of his friends. And there was brand content all over it. There was, it appeared, to have a connection to Heineken. The thing that was interesting about this case is that DB responded. You can read their submission on the ASA website, effectively saying that they had this commercial relationship in place. They'd set out what their expectations were, and hashtag SP they thought wasn't enough either, and that they'd required their influencers they work with to disclose more fully the relationship, for example, hashtag sponsored. So the post was taken down, the matter was settled. The ASA Complaints Board didn't really get into the content of it too much, but it's just, I guess, something to be aware of. If you get questioned as the brand owner, you'll need to be prepared to explain what the relationship is and what your expectations of the influencer were. Similarly, there was a post in relation to the tennis classic where two All Blacks were shown having a champagne pouring competition. Moet was one of the sponsors of the tennis match. So even though in this case the relationship and the advertisement may not have been that clear. It was held there was enough there so that this was an alcohol advertisement, and as heroes of the young, All Blacks shouldn't be promoting alcohol. So the message there is that for influencers in particular, you need to be really careful around things like therapeutic products, alcohol, advertising to children, to make sure that the influencers themselves are really aware of what the rules are. And sorry, I'm not going to pass over to Tania just yet, because I'm going to talk to you about media partnerships as well. So media partnerships, as we're referring to them here, are really both about influencers and about more traditional media and traditional brands. There's been a shift over the past few years from traditional advertising to advertising that's more integrated. For example, through mainstream media, you might put together content to be published in a particular way. You might make people available for exclusive interviews. You might provide incentives in order to get your brand out there through normal media. And it should be, it tends to be presented in a way that's quite organic, so that people come across it and who might not normally click on a banner ad, for example. So again, the risk here is to make sure that the nature of the relationship and the content is clear, and that you are able to sufficiently show that you've got sufficient control in order to make sure that the content is truthful and not misleading. So the degree of control that a brand has over this kind of media partnership is important. If you're just putting out a press release to media generally and someone picks it up, then you probably don't have sufficient control for that to be considered to be an advertisement, although of course it must be true what you're saying generally. But if you have any kind of contractual relationship or any kind of control over content or what's being promoted, then you will need to make sure that firstly it's identified that you have that kind of relationship, and secondly that content is adequately truthful. There is a risk when more than one chef is in the kitchen and things may be amended or editorialized or changed. So I think brands need to be really careful to make sure that expectations are clear as to what content is being put out there and what the level of control is. Things like headlines being changed can have material difference over what the expectations are and what consumers will read from content. And if a brand or advertiser has worked with a media partner, that is a real risk area, including under the Fair Trading Act, where the penalties can be up to $600,000. So this will be a bit of a refresher of what the expectations are for truthful presentation. In relation to media partnerships and native advertising, I think the key things to be sure of are that advertisers hold evidence to substantiate the claims that are being made, that the evidence is easy to understand if it's in the content, and that if there is different views or different impressions, that either it's clear that this is one person's opinion or that the different sides of things are presented. The real risk area arises when something looks like a news story, looks like the claims are unchallenged, when actually this has come from a brand and people haven't been made aware of this sufficiently. So when putting together native advertising, there's lots of different ways that you can identify it, but it shouldn't come to a surprise to any reader or consumer of the content that there's some kind of relationship in place in the background there. So that can be done through branding, it can be done through a special page or section brought to you by a brand, clear identification of who's writing the content and what their affiliations are can help with all of this, and just any identifiers that can be used. So it's really in the interests of both the media partner and the brand to make it clear that this is content that's been contributed to by both, for example, and that there is a relationship there of some nature. So now I'll pass over to Tania to take you on to discussion of social media defamation and defamation generally.
Hi everyone. So I'm going to start off by talking to you about the role that a recent decision in Australia is possibly going to play here in New Zealand when we look at whether or not clients are going to be liable for comments that are put, or statements that are put on their, for example, Facebook, Twitter, and other social media accounts. Some of you will be familiar with the decision in Follow, which is the name of the Australian case. It involved the posting of news article links on Facebook pages run by the various, Fairfax being one of them, but various mainstream media organisations. And in response to that post, as you would expect, and as those media organisations anticipated would happen, the posting of the link to the mainstream news article generated comments and shares and likes and so forth, which drove traffic to their general websites where the full article was available. Now, typically in defamation cases, the first question which arises is whether the content has been published. And in this case, there was a necessary question as to who, in fact, had published the content. The media organisations themselves, of course, published the link on their Facebook pages, but the content which was posted by third-party Facebook users was comprised of content they themselves had generated and then posted. So the court had to decide, well, in that case, given that the mainstream media organisations had effectively encouraged and permitted those comments to appear on their Facebook pages, should the mainstream media organisations be deemed the publishers? Now, this is a bit of a watershed moment, because until then, publication was deemed to be something that you were only responsible for if you knew about it. If we take you way back to the the olden days, in the case of, say, booksellers, you couldn't expect a bookseller to know exactly what was in every single book they put on the shelves. And so it was recognised that the publisher published the books, and it wasn't until such time that the bookseller was told, hey, look, there's something defamatory in this book, you should remove it, that the bookseller could be held responsible for publishing the content of the book by handing it over to a customer. What the Australian courts did in this case, though, is analyse effectively the rationale for the mainstream media organisations leaving comments available. And the court received a lot of evidence in relation to whether the mainstream media organisations were able to effectively hide or block content posted by users. They looked at why it was that the mainstream media organisations hadn't done that. In other words, why they hadn't adopted stricter protocols, effectively blocking every statement posted by a user, and then adopting a post-vetting sort of procedure whereby it would be somebody, or in some cases, multiple people's jobs to read through the comments and then permit them to be viewed by other Facebook users in a general way. And the court took what was an interesting approach and said, well, the publication occurs at the point at which a user, so another Facebook user, can comprehend what has happened. And the key stage in comprehending what is in fact posted is not the point in time at which the third-party user presses post, but the point in time at which the Facebook page operator, so in this case the mainstream media entities, permitted that to be viewed. And so, in other words, what they said was, well, because the mainstream media organisations have encouraged this content and have taken an active step in permitting that content to be viewed without any sort of pre-publication vetting process, they are in fact responsible for publishing, or in other words, conveying the content in a comprehensible format to other internet users rather than the third-party posters. So this is quite an important development in Australia, and as some of you will know, the New Zealand courts tend to follow UK and Australian developments quite closely, because the economies in which we operate are similar, and we have a lot of similar and crossover trans-Tasman business in particular. Now, the important thing to note probably is that this decision in Australia won't apply just to mainstream media entities. It will also apply to brand-driven Facebook, Twitter, etc. accounts operated by any sort of, for example, an FMCG company, whereby content can be posted by users. Previously, we were reasonably comfortable here in New Zealand that any of that sort of content that was posted, as long as it wasn't incredibly foreseeably likely to contain defamatory content, then you weren't responsible, or your clients weren't responsible for what appeared on their page, on their brand pages, until such time as they were made aware that there was a problem with the content and then failed to take it down. There is a risk, however, now with this Australian decision that a much more purpose-driven analysis will take place. In 2014, which has popped up on your screen, the New Zealand courts did consider what should happen in the event that content was posted. Now, this case related to, you'll be familiar with the trial of the Kahui twins' father, who was acquitted of their murder. But during the trial, there was quite a lot of suggestion that, in fact, the mother, Maxina, could have been responsible for the twins' unfortunate deaths. That theory gained quite a lot of currency generally in the population, and so as a result of that, there was a freelance journalist, Ian Wishart, decided to publish a book in conjunction with Maxina King. Just in advance of the release of that book, Christopher Murray established a Facebook page, which was entitled Boycott the Maxina King Book. The page was only active for a couple of months prior to the release of the book, but it generated quite a number of extremely negative comments about Wishart. And so as a result of that, this defamation claim arose. Now, the New Zealand Court of Appeal, of course, then was looking at a slightly more private Facebook page, in the sense that it wasn't a Facebook page generated or whose existence was designed to generate an economic or financial benefit for a brand owner. But nonetheless, the essential question was, who's responsible for the publication of these defamatory statements? And the New Zealand Court of Appeal held that a private Facebook page, you are not liable for defamatory statements posted on the page, because in that context, there's no ability for a private Facebook page holder to, in fact, do that pre-vetting process that the Australian courts, you'll recall, thought was the key to who published things. And a private Facebook page, you can only remove comment after the fact. So in other words, in a private Facebook page context, you would only be responsible for the content if you knew there was content there that was defamatory and then failed to take it down. And this is basically the same sort of analysis that goes into an innocent dissemination defence. In other words, back to the booksellers, you're not responsible for something if you're handing it out not knowing what's there and can't reasonably be expected to, in fact, have known what was there. The court, however, left the door open by stating specifically that cases where they are which concern the liability for internet hosts would be extremely fact dependent, and it's important to note that the Wishart decision concerned quite a different sort of Facebook page than the Australian courts considered. And the key differences, of course, are in the Australian context, there was a possibility to delay or in fact stop publication of statements before they were released. That situation didn't exist in the Wishart decision in New Zealand. The media entities in that case, of course, the whole purpose of the page was to generate comment and statements and links and to further disseminate their own content. And specifically, the media companies should have been aware, given the subject matter of the articles they were posting links to, that the content was likely to include defamatory material. So after the decision in Murray and Wishart in New Zealand, Parliament here introduced a safe harbour for digital platform users, which is an interesting potential block to the importation of VOLA, but not a complete one. So some of you will be aware that the Harmful Digital Communications Act provides that if internet platform hosts receive a complaint about content, they have 48 hours in which to notify the author of the statement, so the person who in fact posted it. And if no response is received within 48 hours or the author consents, then that content has to be removed. And if the material is removed and that process is followed, then there is no liability for the person who hosts that platform. So it's incredibly important at the moment that brand hosts are aware of this particular safe harbour provision and have a process in place to ensure that they follow that protocol expressly. The interesting part about the Harmful Digital Communications process is that it only applies if there is this specific process initiated by the complainant. There's no obligation on someone who sees content they don't like on a brand website or on a Facebook page to, in fact, use that process themselves. So the upshot of all of that is that there is an increased risk now with taking a hands-off, post-vetting sort of an approach to people posting comment and opening up brand pages for content like that. So what happens then is it's important to be aware that there are certain things, absent shutting down all comment and completely confining any sort of natural spread and the viral nature of some campaigns that of course is to be encouraged. There are some things you can do to effectively escape liability for defamation, notwithstanding that third parties are posting material on your website. This analysis is also relevant to influencers and the use of sponsored content. When we're looking at defamation, the test is a three-part test. The first is that something has to have been published, and it has to have been published to someone other than the person that it's about. Usually that's not a problem in the sorts of instances that we're talking about. So the second one then comes into play, identification. There has to be some sort of identification of a third party, be that an individual or a company. You don't have to say their name exactly. There are plenty of ways of implying who you are talking about in a way that sufficiently means the general populace will know who you mean. So that brings us to the third part of the test is what you've said or your influencer has posted defamatory. Now, there used to be a very convoluted judicial definition of what was defamatory, but the key point now is to bear in mind that if what you have said or your influencer has said or the third party has posted is derogatory, it will almost certainly be defamatory. Now, once you have those three things, you have something that is defamatory. The next question isn't how do we make it not defamatory, it's how do we get away with that? Is there some way of defending what has been published? And the main defences are truth, honest opinion, absolute privilege, and qualified privilege. Now, absolute privilege is not something that will, generally speaking, apply to you or your clients. That's the privilege that, for example, Winston Peters likes to rely on when he's speaking in the House. Those sorts of things don't carry on to you. Qualified privilege is a form of ability to, for example, report a fair and accurate report of what happens in court proceedings. And so that's why we can say all sorts of things as a trial progresses without ultimately, if the person's acquitted, being liable in defamation. So because those two defences are quite particular to their circumstances, the two we're going to talk and are unlikely to apply to influencers or brand content generally. We're going to talk about truth and honest opinion today because they're the most likely to arise. Now, truth is an interesting one. The defence of truth is only available if you can show that what people took from your post or your influencer's post is true. It's not a question of saying, well, what I wrote or what was posted was true. This is where, unfortunately, whatever you can read between the lines is whatever you have to justify as true. And it has to be justified as true using evidence that a court will accept. So somebody's view that it's true or things like that are not, unfortunately, going to cut it. Now, you're not going to know what you have to prove is true until the person who takes issue with it tells you what they think other people thought you meant, which makes the defence of truth, unfortunately, quite difficult to establish and a little bit less obvious than you would otherwise think. Which brings us to opinion. And in a defence of honest opinion applies as long as the opinion is genuine. Now, it can be an extremely unreasonable opinion, but as long as it is the person who expresses its genuine and honest opinion, then that's the first hurdle overcome. Now, the things that you can do to make sure that your honest opinion defence is as watertight as possible are to make sure that opinions are clearly expressed as opinions. And this can be as straightforward as putting those keywords such as I think, I believe, in my view, in front of whatever the statement your influencer or your brand ambassador wants to say. What it also means is if you are pre-moderating content that third parties are posting, you can amend it to make sure that it contains those sorts of prefatory statements. Now, the last thing you have to make sure you do is include in the post or associated with the post enough of the facts that the opinion is based on for the people who read the opinion to decide whether they agree or disagree with it. And that's really the crux of the honest opinion defence, is for readers to be able to, or viewers, to be able to see this is an opinion, this is what the opinion is based on, and I can therefore choose to agree or disagree with it. It's not presented as a fact I have to accept as true. It's presented as an opinion that I can then have a think about and decide whether I agree with it or not. And then overlaid across of all of this, of course, is the New Zealand Bill of Rights and the right to free speech. This is not a right, an absolute right to say whatever you like. It's balanced against other rights and freedoms, the key one in the defamation context, of course, being people's reputations. And so the need to balance those two rights is achieved through the test for defamation, that publication, identification, and something derogatory test, and then the ability to honestly express a genuinely held opinion. So that brings me to the conclusion of what I was hoping to cover with you today, and I believe we've got some time left for questions.
Thank you, Kristin. Thanks, Tania. We have had quite a few questions come in over the, sorry, I'm just moving them up where I can see them. So the first one, it goes back to your presentation, Kristin. There are, Okay, first question regarding hashtag sponsored or hashtag spawn. Would the same be true of hashtag promoted or other terms that are similar to platform mechanics?
Yeah, I think so. So in the ASA guidelines, they talk specifically about sponsored, and that was one of their frequently asked questions, is why hashtag sponsored wasn't potentially listed. Well, it wasn't listed as one of their recommended options. I think that things like hashtag promoted could be also potentially blurry. So I think that it's a matter of having a look at the overall nature of the post and whether it's clear that it's actually promoted content from the brand as opposed to a promoted post that Instagram or someone else has promoted or the influencer themselves has pushed forward.
Another question, who's liable if disclosure about a commercial relationship isn't explicit enough? Is it the influencer or the brand or both?
So what ASA says to that is, predictably, everyone they could possibly blame for it or make responsible could be responsible. So what that means is that the brands and the influencers will all need to be quite careful about it. Obviously, this gives rise to a bit of concern from brands who are, doing their best and making it clear what their expectations are, and the influencers don't follow that. I think at that point you need to consider what the PR implications are for what you're going to say to the ASA. So if you can say to the ASA that this is the procedures that you as a brand had in place, that will put you in much better stead in terms of how you'll come out of it at the other end. And of course, ASA doesn't really have much in the way of actual teeth. They can suggest a post be taken down or an advertisement be removed, which is invariably followed, but it's really the reputational risk that is the big stick that they wield. So the more confident you can be that the people you're working with are cognizant of the rules and will follow those, the better.
Yeah, maybe I could add as well, in terms of the Fair Trading Act, if the lack of disclosure goes sufficiently far to make the post misleading and deceptive in that context, then again the Commerce Commission can join any person or party they think is responsible for the chain of publication, and the same applies in a defamation context. Every entity involved in that chain of publication is added, rather than one taking the place of another.
We have a question here from someone who is a publicist for a professional theatre company, and who says that it's usual practice that the industry give away comp tickets for opening nights of shows. They would usually be for reviewers, influential media contacts and celebrities. Should we be asking them to use a hashtag if they were sharing about the show on social media? Using hashtag advertisement in this context doesn't seem quite right, but by the sounds of it, the onus is on the publicist for it. What are your thoughts?
So I think it sort of depends it always all depends, but what the nature of the relationship is. I mean, if you are sending out tickets to reviewers or people who might be seeing the show and you're not putting any expectations on them, it's more likely that this will just be seen as the kind of relationship where you can give tickets to people who you want to review your shows. If you are giving it to celebrities who you expect to post on the red carpet, for example, if there is a particular event or launch that you're hoping that they will post about in a positive way, that's likely to be more of an issue. Again, it was interesting, the former sort of guidance given by the ASA said that if you're just giving people a gift, for example, or a product, and you're not saying how that product should be referred to or advertised or the claims that should be made, then that was probably not an advertisement. But this recent guidance suggests that in the context of influencers, it probably is. So I think it's really thinking about what the purpose is. But I think if the purpose is for genuine review and you're not sort of suggesting that people take a particular view, I think that's probably relatively low risk. But yeah, that would be my take on it.
How does it work when a magazine offers an advertising package, and in that in this package, it is an added value to talk about one of your products, and this will be on a page with multiple products. What does a brand agency or PR company do to ensure that they disclose this?
Yeah, so I think that if you've got a contractual relationship in place, you would want to have something in that contract saying how content will be identified, and probably it's the kind of thing you might want to have discussions with the magazine about, as to how they draw the line between advertorial features, which is something at the very sort of far end of the spectrum, and sort of genuine reviews of content. So it is a slightly difficult one. I think that, yeah, it's about making sure that whatever's in your contract there is as clear as possible, and that you're comfortable with how things are being promoted, such that people aren't going to be misled about what's going on in the background.
We've got a couple more questions on the influencer ones, and then I think we move over to the defamation, which there are also several questions. Okay, in regards to up-and-coming influencers who have not been sent product and instead buy it and review it, what control or how's a brand covered if that influencer doesn't use the hashtags, which of course they shouldn't be? Yeah,
look, that should generally be fine. Because a lot of the up-and-coming influencers will be wanting to post content and review things in order to build up their own profiles and build up their reputations in that way. But if you genuinely have no interaction with them, then that's just a matter of explaining that if there happened to be a complaint. I think we can expect to see more complaints about influencer conduct generally rather, but it's the larger ones which are more likely to give rise to issues. I had been considering as well, if somebody is giving out product on Queen Street to people and then they post about that, what the issue would be there. I think that if you are not specifically targeting a person to post about that content and promote your content, then it's probably much safer than someone going out and buying your product, or you just giving out free samples generally.
Okay, so someone posts that they follow a wardrobe stylist who actively works with clothing brands to secure workshops in store and malls and things, and she posts every day on Instagram, clearly wearing a single brand of clothing, which she presents as, don't you love these pants I'm wearing, or this dress colour is amazing. And she also adds in, these shoes look so good with it, or she'll point out that there's a shop with these said brands in it and their new season's really fantastic, and then a hashtag brand name. There are no buyer codes, or is this advertised content? Who's at risk here? Can the wardrobe influencers simply state these are her favourite clothes and brands, and that it's not an advertisement?
Yeah, so it sort of depends how the page as a whole is presented. So if the page is clearly her business as a wardrobe stylist, and it's clear from the context of the page itself that she's going to be receiving product and reviewing product and commenting on product, then you may not need to state on every post that each post is an advertisement. However, there will be lines where if people come across a post in isolation, and they may not be familiar with the person's page, that it needs to be stated more explicitly. So again, it sort of depends how people are likely to come across it, and again, whether it's obvious to consumers or not that there's some sort of commercial incentive in place.
Okay, so back over to your components, Tania. Re-opinion, is this relevant for media comment too? Do we have to be careful when we put out a media release with a client opinion in it to include the facts and then clearly state, I think, in my opinion, etc. Do this anyway, but someone is just interested from a legal point of view.
My favourite point of view. So yeah, the short answer is yes. Anything that gets published that is derogatory about, say, another entity, and I'm assuming this is the sort of context where a competing brand will be in trouble for something, and then the media go to your client for comment about what their competitor has done, and so inherently there's a prospect that what you say about your competitor is negative. In that context, what you would want to make sure is that encompassed in the article that the comment appears in is sufficient facts about the background for the ultimate readers of the media content to be aware what the opinion is based on. So it's always safer to give one or two of the key facts and then say, so therefore in my view that means, etc., and carry on. And that's always the safest way of approaching it.
In terms of Facebook comments, is catching and deleting them enough, or is it best practice to filter first? I guess it's how long is a piece
that's the $1 million, or not quite $1 million question, but it is the big question at the moment. So at the moment in New Zealand, it's enough to remove them once you're notified that there's a problematic statement there. That's what the current New Zealand position is. The safer thing though is to pre-moderate, so to filter them all prior to publication, and that way you don't even open the window for a proceeding to be brought against you, because I think it's fairly inevitable that we will get to the point here in New Zealand where it won't be a defence anymore to say I just didn't have the resources to pre-moderate all of the comment. The courts will get to a point here eventually where they recognise that there is essentially an economic benefit to a volume of comment, and therefore will say, well, hang on a minute, you can't take the benefit of that and then tell us you didn't have the economic ability to filter them first. So I guess the short answer is legally it's enough at the moment to catch them afterwards and remove them quickly, but the safest thing would be to start pre-vetting what goes up, at least in circumstances where you think there's a reasonable likelihood that the comment is going to be inflammatory.
And what if omitting the other side's truth? Can it still be considered an honest opinion?
I'm sorry, you just glitched just as the question came out.
What if the media is intentionally omitting the other side's truth? Can it still be considered an honest opinion?
Well, as long as it is the particular person who expresses the opinion's genuine opinion, then that will suffice. There can be multiple different opinions, and they can all be genuine and honest opinions and completely at odds with each other. And as long as the particular opinion that is expressed, even if it's a one-sided opinion, is genuine, and those three things are followed, so it's obviously an opinion, the facts are there, and you can decide whether you agree or disagree, then that's fine. There would be potentially a separate issue which is unrelated to defamation in terms of media council complaints if a contentious topic is being deliberately written about by the media in a one-sided way.
So a question from someone who works in healthcare, who says we have a number of people who are champions for a ministry healthcare initiative. They are telling their story but are not being paid. Should they be identified as promoters?
So I think that my answer to every single question that you've asked me, it all depends on context. So you need to be really careful when talking about testimonials or when talking about people's particular healthcare experience. If there is a chance that people will look at what's being said and think that it's just a entirely genuine, objective, nothing to do with the healthcare provider, it's just someone has been motivated to say what a great time they had in hospital, then that could be problematic. I think that you'd want to have some sort of more express link there. If it's going to be, for example, posted on the page for the client, the health provider, then that should be clear enough that that's an advertisement in itself. So it's really if people are likely to be misled into thinking that these are just genuine people who are sharing their health stories without any incentive or connection, then there's potentially an issue and should be disclosed more fully.
And a comment from someone who's doing PR for PR. Would PR companies be expected to put ad ahead of their social content if they are sharing either coverage they've achieved for a client or products of a client's, etc.? There's obviously a commercial relationship, but the relationship is not for the purpose of social media advertising.
In general, I would say no in general, because if a public relations firm is putting out content there, I think it's likely to be expected that there will be some sort of commercial relationship there or some sort of other thing. One thing that the ASA did say is if a business receives free product from another business, it's the same situation as with influencers. So if somebody contacts your PR firm and provides you with content, or if the relationship is not quite what people would expect, then you might need to disclose more fully. But in general, if you're promoting your clients and your clients' products, then there's an expectation there that there is that relationship. So you probably don't need to explicitly state advertisement if it's coming from a PR firm in an obvious way.
Yeah. In the same vein, what about working with charities who provide funding to individuals and other organisations? If they post about the charity and the funding that they've received on their own channels, do they need to say ad?
This is the kind of
the charity sector, you know, yeah.
Yeah, because you can imagine that if somebody got you know, a lottery grant that allowed them to go overseas or allowed them to, you know, do a particular activity or bought shirts for a sports team, that is the kind of thing that people would want to promote. I guess it would depend whether the post itself makes it clear what's happened, that they have received from something from the charity or that they've had a good experience with the charity. That in itself may be enough. If there's actually a relationship between the charity and, you know, an influencer or a person where there's been a deal that they'll make a post, then that's something that really needs to be made clear. But if people just want to say thank you to a charity who has supported them, then that is a thing. And I should say that, yeah, it's a matter of just reviewing each post carefully to the extent that you're able to. And if there's doubt about whether you should be disclosing or not, there is, you know, there's guidance both online, and also there are very helpful lawyers who can look at things and help you out, because we do spend quite a bit of our time reviewing posts and considering the extent to which disclosure has been made clear enough or not. So there's always options there for getting, in those borderline cases, a bit more guidance. But overall, it's the impression that people will get from it, and whether that's true and correct or not.
So if people post defamatory content on your brand's Facebook page, can you still be held responsible if you closely monitor your page and either delete, amend or hide such content? If you can be held liable, it seems like the only option is to turn off the third party's ability to comment on your page, which defeats the purpose of trying to encourage engagement.
Yeah, that's exactly right. And that's why the decision that we talked about today coming out of Australia is so concerning. It effectively does say that you are responsible as a publisher if you allow all of that content to be there and only remove it after the fact. In New Zealand, we aren't quite there yet, but as I said earlier, it's the sort of thing that we can see the New Zealand courts being likely to want to import, notwithstanding the Harmful Digital Communications Act sort of safe harbour that we currently have. Of course, it's always, you have the ability to, if you have the ability to post moderate, then you should do that if you're not wanting to turn off the comments. But what that does mean is you need to take quite an active role in ensuring that as soon as you are aware that there is content there that's defamatory, you remove it immediately. And in a lot of instances, in a practical sense, that will resolve the problem and sort out any sort of real risk of defamation proceedings being brought against you, because ultimately, if the content hasn't been up for too long, it won't have been shared too far, the issue can effectively be resolved by removing it, potentially posting an apology if that's required, and hopefully that will then be the end of it in most cases.
Question for those working kind of in the trans-Tasman environment. Does the situation around influencers in Australia look similar? Would a New Zealand business working with Australian influencers need to do anything differently?
So I haven't considered Australia specifically in this, but it's definitely a movement all across the world that regulators are becoming more interested in influencers and how things are presented. The law is very similar between New Zealand and Australia, and in my view, the ASA guidelines for influencers are relatively conservative. So I think that if you're following best practice for New Zealand, that's likely to assist you in Australia, but you would need to check that further. But it's a similar sort of idea that you need to be clear so that people aren't being misled as to what the relationships are.
Thank you. We've had lots and lots of questions, and we won't have time to answer them all because we're now sort of sitting at 1:10. But we've also had lots of fantastic thank yous from people as well, typing things in. So thank you, Tania and Kristin, for joining us today and sharing your expertise on this topic. We have got other questions. I don't know when might be able to fire them through via email to you and perhaps answer them. There's one or two ones, and some of them are a little bit more detailed and specific. But we also have a short survey for all the attendees when you close this. So please take the time to respond to this. Thank you everyone for joining us, and we'll be sending out a link to the recording, hopefully later today or early tomorrow morning. Thanks everyone. Enjoy the rest of your day.